Okay, hello everyone, and welcome to our webinar. Good evening or good afternoon or good morning, wherever you are. So thanks so much for attending. So I'm Nessa Lynch and I'll be chairing and facilitating the session this evening. And this is held under the auspices of the Centre for Children's Rights and Family Law at UCC here in Ireland. So I'm going to shortly introduce our panellists. And then I'll offer some framing remarks to get us going and we'll get into the discussion. So a couple of housekeeping matters. So the session will be recorded, but it's in a webinar format. So nobody is able to see the attendee list or your names. You'll just be seeing the presenters on the screen. It is possible to submit questions through the Q&A function, but again, these won't be seen by the others. Those will just be seen by the organisers. So we're aiming to run for about an hour because that's probably enough time to concentrate on the screen. So first of all, I'm going to introduce our panellists. So we are joined by Ian Lammy, who's a professor of clinical psychology at the University of Auckland in New Zealand and the chief science advisor for the justice sector for the New Zealand government. We're joined by Fiona Guy-KC, who we're just getting up on the screen at the moment, a senior criminal defence barrister of Montrose Chambers and Bridgeside Chambers in the South Island of New Zealand. We're joined by Cliona Buckley, who is a barrister specialising in criminal law in Ireland and a graduate of UCC. We're joined by Conor Mahoney, who's a professor of law at UCC, who specialises in the interface between children's rights and constitutional law. And we have Ursula Kilkelly, who's a professor of law at UCC and the vice president for global engagement, who's a leading global expert in youth justice and children's rights, particularly children in detention. And we've got Liz Grady-Hood, who's a researcher at the School of Law, who supports Professor Kilkelly and Professor Lundy in their work, and who's the co-organiser and will be keeping an eye on the Q&A. So before we begin the conversation with our panellists, I just wanted to offer some brief framing remarks on the topic. So in the narrower sense, the opportunity to come together was prompted by the decision in CC, which was a case about murder sentencing in Ireland, which is very significant in relation to the sentencing of this group. So murders perpetrated by children are thankfully rare, but they're not unknown. And indeed, we had a case just today in Ireland of the sentencing of two young people for their part in a gangland murder. So this is a live issue, which the courts have recommended that law reform should be forthcoming. So my connection to this and why we have particularly Ian and Fiona here today is that the Irish Supreme Court in their recent decision relied quite heavily on a New Zealand case called Dickey and others, which was influential. So I was living in New Zealand at the time. Fiona was counsel in the case along with Lisa Preston KC, who is now a judge at the High Court. And Ian and I both contributed expert reports for that case. So we're delighted to see the global impact of this case and that it's contributing to progress in other jurisdictions. So the other jurisdiction mentioned in CC was, of course, the United States. And we were trying to get our colleague and friend Marcia Levick here this evening, who is a lawyer and then the just retired director of the Juvenile Law Center in the US. So she's enjoying some well-deserved vacation time at the moment, but I'm going to catch up with Marcia in a couple of weeks and record an interview, which we will post as part of the recording for this evening. So in a wider sense, myself, I've written quite extensively on the sentencing of children and young people for murder, along with colleagues, some of whom who are here this evening. And it's an issue that is to the forefront in the global conversations on child justice. So in a global perspective, although there's lots to progress in terms of implementation, the idea that children should be treated differently under the law and receive special protection is embedded at an international level. Common law countries, especially with the importance of diversion and detention as a last resort, means that the vast majority of crime and offences committed by children will be dealt with informally and within the child justice system. For those who have formal court action, it should be a specialised children court with special principles and outcomes. However, when we get a murder or manslaughter case, generally what we do is exclude the child or young person almost completely from the protections of the system. So they're removed to the adult system where they're tried in an adult court and with an adult sentence, leaving them in a vacuum. And so in my comparative work with others, we've demonstrated that common law countries almost universally exclude children from the protections of the youth justice system when they have a murder or manslaughter charge. Civil law jurisdictions fare a little bit better, but often in those cases, care and protection detention or mental health detention ends up being the case. And so I see we've got Fiona with us. Fantastic to welcome you here, Fiona. So the literature, the academic literature, has often focused on, rightly, around the problems with the current system, the problems particularly with life imprisonment and the impact on children and young people. But we do have a lack of understanding in the literature on what a principled approach might look like and what we should do instead. And as we'll hear tonight, we've got two principal lenses for thinking about reform. So the first one would have been very much developed in the US, and I know we've got some of our American colleagues listening in tonight. So through the work of the Juvenile Law Centre and other civil society groups, and particularly the Juvenile Justice and Brain Development literature funded by the MacArthur Foundation, has led to a number of important strategic litigation cases in the US, which overturned the death penalty for juveniles and the sentence of juvenile life without parole. But in Europe and other parts of the world, we would probably rely more heavily on the human rights framework, which would say that children have special rights based on their status as children. But as we'll hear in relation to some of the cases tonight, we've seen those two lenses coming together as well. And the other cross-cutting issue, just to highlight before we get into our discussion, is around obviously young adults. So many of these cases deal with under 18s, but we've seen the case of young adults, 18 to 25-year-olds, appear in the literature and the case law around the world also as a special group deserving special attention. So some would argue these should come into the YJ system. Others think that they should be a category of themselves. So two other contextual remarks just before we get into our discussion. I think as lawyers and criminal lawyers in particular, we often approach these cases in a very analytical way. But I think it is always so important to remember that these are real cases with real people, and particularly I think cases where there is a child perpetrator and a child victim, which is so often the case in these things. And it's also important for us to think about the rights and interests of victims, families, and the public as well, as we will get into. And secondly, a reminder that some of the cases in Ireland certainly are coming up for resentencing. So we will be cautious, and then the panelists will moderate themselves in this way around specific comment on some of the cases for that reason, but we'll speak in general terms. Okay, so let's get into talking to our panelists. So we're going to start in terms of how we'll work this. We're going to start with Ian, who's going to talk to us about brain development. We'll move then to Fiona to talk about the case of Dickie. We'll invite Cliona then to reflect on the case of CC in Ireland. Then Ursula and Conor are going to offer those more cross-cutting academic perspectives. Ursula from the perspective of children's rights and youth justice, and then Conor from the perspective of children's rights and constitutional law. So I'm going to hand over to you first, Ian. You're an expert, a clinical expert in relation to working with young people who offend, and you've assessed a lot of these young people for various cases. So from your experience of this cohort, what would be some of the characteristics and background of these children and young people who come to notice for very serious top-end offending like this?
Well, thanks, Nessa, for the opportunity, and good morning, everybody, and good evening, everyone. Nice to be here. Look, I think, I think the first thing is that children don't end up in these situations for no reason. It's very, very rare that a child would commit murder coming from a family that is quite functional. And I think that they often have histories, well, they typically have issues of trauma, neurodiversity, conduct problems, learning issues, sensory information abnormalities, poor frustration control, and obviously their brain is really very impulsive, not fully developed. They often maybe have head injuries, and sadly experiences in care where they can have adverse experiences in care. And we often see families where there's quite significant levels of child abuse, neglect, and family dysfunction that is intergenerational. So it's not just for that child, but it goes back several generations. And I think what this gives rise to is a young person who is really quite different to other children, and often they attract other kids that are similar or maybe similar to themselves, because that's where they feel as though they can fit in and are accepted. And they're often rejected by the school system, so that may be stand downs, expulsions, rejection from peers, rejection from teachers. So their early childhood experiences in primary school, and I'm talking about going back to probably the age of 5, 6, 7, can be really, really quite disconnected and disjointed. And so you have a child that really presents potentially as quite antisocial, as quite objective, objectionable to society. But inside that, you have a young person who's quite distressed, anxious, often have mood disorders in terms of depression, low mood. And that's really what you have. And I think, people talk a lot about the brain development, the frontal lobe not being fully developed to the mid 20s. I think if you think about drugs, alcohol, head injury, all that impacts on that. And I think, some people may not have and I think it's a cocktail of things all coming together. So in a very short snapshot, they have, that's kind of that's what I would summarize it as, Nessa.
Thanks so much, Ian. And I know those of us who are familiar with reviewing those sentencing remarks, both in New Zealand and other jurisdictions would find that really familiar. But of course, sometimes we do get young people as well who effectively come out of nowhere and it's their first offence. But I agree that most of them have that really overlapping vulnerabilities. So in terms of that evidence, Ian, that you've described around the characteristics of that cohort, like from a clinical perspective, how should we respond to such cases? And I suppose particularly, I know in the Brown case, you gave evidence around the impact of life imprisonment and long sentences for this type of child and young person.
Well, really, I think you have to, certainly consider this and take this into account, because a young person's sort of sense of time, sense of what that means to them in their life, they really don't have the same maturity that you and I would have. And their whole sense of, life, of time is very, very different. And I think so, looking at that in a neurological perspective, but also in a social and a psychological perspective, I think you really have to connect the two together. And it's not just one or the other, but I think you have to look at the impact of them and their potential, but also their ability to really understand fully the consequences of what they're doing and the implications for their lives. Obviously, sadly for the victims and the victims' families, that's really key. But I think the other side of it is their ability to see time and space and sequentiating is really very limited and very different to yours and mine. And I think, I've just been working with young people yesterday afternoon, and a young person who's actually sadly appearing in court in 2 months' time, despite all the sort of things that we could do, his ability to actually make good informed choices was just less than yours and mine. And it's like you think, how can that sort of connection not be there? But it just isn't there. And he's a young person in his early 20s.
Thanks so much, Ian. And we'll come back to that point probably about the young adults as well. So thanks so much. So I'm going to move to you now, Fiona, and thanks so much for joining us, especially at this really early hour. We really appreciate it. And And in the introduction, we talked about, I suppose, how the three of us and others were quite excited to see that the Dickey decision had such an impact at the other side of the world. And I know as well that there's some Canadian colleagues listening in tonight who are taking a similar case. So can you talk to us about this decision, which obviously you were acting particularly for Brown, who was one of a group of young people, but this decision, which is known as Dickey and others. What were the facts in that situation, and what was the situation at the time before the decision in relation to the law on sentencing for murder?
Tēnā koutou katoa. Hello from the bottom of the South Island of New Zealand. So this case was before our Court of Appeal, so it wasn't our final Court of Appeal, which is the Supreme Court, and it was heard in July 22, and we got our decision at the beginning of 2023. It actually involved 3 young people from 2 different cases. So from Invercargill, there was Georgia Dickey, who was aged 16, and Christopher Brown, who was 19. And from Christchurch, there was a young woman aged 18 called Katrina Epiha. So Dickey and Brown and a principal offender were involved in the murder of another young person. He was lured to the local stadium with the promise of a romantic encounter, as the court called it, by a young woman. There were 7 young people involved. As Ian suggested, they all had similar characteristics, meant they were homeless, they had similar backgrounds. The principal offender stabbed the victim multiple times. He pleaded guilty. And in fact, he is now, side story, last week had an appeal heard on the basis of a lack of parity now between his life sentence and those of Dickey and Brown. Georgia Dickey held the victim while he was being stabbed, and she pleaded guilty before the trial and gave evidence for the Crown. Christopher Dickey had participated in a lengthy interview with the police to help them without legal advice, where he said he knew that the principal had a knife, but he didn't think he would use it. And Brown was found guilty at trial. And the trial judge found it was likely that he was convicted on what we call a common enterprise basis, that he knew that it was likely that a murder could happen. The young woman who lured the victim to the stadium was convicted of manslaughter. So those were the background facts for our 2 clients. Then Katrina Epiha had stabbed the former girlfriend of her new partner with a large knife after an argument. The victim died at a scene. She was disarmed. She pleaded guilty to those charges, and the Crown accepted that she didn't intend to murder, but it was a reckless murder. So each of these appellants, and what's significant, received essentially a life sentence with a 10-year parole, which was the minimum parole period that could be imposed if you get life imprisonment in New Zealand. I heard about the Epiha appeal. We sought to join them together so the court could consider a number of similarly situated people. So that's what went to the court. But all of these appellants had more than youth on their side in the form of mitigating factors. Katrina Epiha was described as being born into brokenness, which I thought was very compelling as a description. And for her, that meant she was a 3rd generation in a gang family in New Zealand. She was using drugs and alcohol by the age of 6, put into state care at the age of 7, suffered physical, psychological, sexual trauma and neglect from early childhood. Christopher Brown was neglected in his birth family, uplifted at the age of 2, placed into state care, and then moved through some 50 foster homes before the age of 6. He was abused as a child. He had an IQ of 76, which was borderline for intellectual disability. He was described as having profound mental health issues. Georgia Dickey had had a sort of better life than these 2, but she too had been exposed to domestic and gang violence. Homelessness from the age of 15 led to drugs, alcohol abuse, left school, and she reported the victim had indecently assaulted her on a previous occasion. Initially, she had little remorse, but that changed as she aged. So I've put up, to answer your second part of that question, what was the law in New Zealand before this? Don't know if those slides are able to be seen, but our test is in section 102 of our Sentencing Act, that there is to be a sentence of life imprisonment unless, given the circumstances of the offence and the offender, a sentence of imprisonment for life would be manifestly unjust. There are no special provisions in New Zealand for children or young people convicted of murder, and our court recognised that we were rather out of step with the rest of the world in that regard. So they too had to come in within that manifestly unjust. And so our law before this had been set in a case in 2003 where our Court of Appeal held that a finding of it that a sentence of life imprisonment is manifestly unjust is likely to be reached in exceptional cases only. And at the time, the Court of Appeal placed weight on an ability our parole board had to reduce the parole period, but that actually went away and was repealed the year after that case. So I've got a slide there about the numbers and what had happened to people in sentencing up until this decision. And that clearly shows that it was indeed exceptional to get less than life if you were a young person. And of the 171 who had been convicted as adolescents or emerging or young adults, only one child and one emerging adult had ever received anything less than life imprisonment since the Sentencing Act had come in. So it was exceptional. Repaira involved young people. We then had a case called Churchwood in 2011 that involved cases with aggravating features which weren't present in the Dickey and Brown case. And that case really dealt with where there might be a presumption of 17 years minimum MPI. But Churchwood was significant in New Zealand for recognising youth and the neurological developments that had been known up till that stage, but it hadn't affected life sentencing for young people. So that's where we got up to before Dickey and Brown.
So I wonder, can I direct you, Fiona, to we talked at the start about kind of brain, there being two lenses, the brain development, which is used very heavily in the US cases, and the more human rights lens, which we'd be more familiar with in the EU. So in terms of, obviously the court reached a decision that there should effectively be more use of the manifest injustice provision, or that they're going to allow themselves more flexibility in future cases. So which of those lenses or both was relevant in them reaching that decision around that there really should be less use of the indeterminate sentence?
Well, I think it's important to remember they had to, or we were asking them to do something slightly different to what had happened in a decision of the Court of Appeal. So they, in our precedent system, had to show that there had been some changes since that earlier case. While they reviewed the human rights provisions around the world, that was not directly stated as one of the reasons for their change. They did, however, refer to, amongst the four different factors, the neurological science and the brain development information in their reasoning as to why there could be a change. But they were very careful to say they weren't creating an exception for young murderers. They said that's only Parliament could do that in our system. But they did recognise that our sentencing approach as well for all offences has changed, and we're far more open to considering the range of mitigating factors. And they identified three matters which we hadn't really focused on before about manifest injustice for young people sentenced to murder in New Zealand, and that was the indefinite nature of the sentence. And we had some great evidence from Dr. Lambie, Professor Lambie, that of the difficulties of young people to understand what that even means, and how that could be harmful in itself for them. Our 10-year MPI, which they said was a very long time, and that it would be way more heavily, particularly on those from difficult circumstances, and the impact of lifetime parole, where we had some really interesting evidence about what that actually involves in reality, reporting to a probation officer every 3 weeks for the rest of your life. The fact that in New Zealand only 2 people have ever been removed from conditions of parole. They both had doctorates and had spent 20 to 25 years on parole conditions. So those were considered relevant, and for those reasons, that's why the court considered for each of these appellants that it would be manifestly unjust, and instead we receive finite sentences with minimum periods of parole. So those, yeah, you're probably aware of what those are. Yeah.
Thanks, Fiona. And I think that's an interesting point that we may come back to later about that idea, which I think is relevant is in Ireland and other jurisdictions as well, that the courts can obviously only go so far in terms of their structure and function, and that some of these larger questions are for Parliament. So we might come back around to some of the issues with the New Zealand decision, but I'll move over to Cliona now to talk to us. You're part of the team, Cliona, in relation to the recent case of DPP against CC. And like Fiona, can you take us through briefly the facts in that particular case? And again, what was the legal position beforehand, and what will be the impact of this decision?
So, good evening, everyone. I'm delighted to be able to speak with all of you this evening in relation to CC. So, just for some of you who are not familiar with the facts of the case, CC was convicted of murder in the Central Criminal Court towards the end of 2022. So this was following a retrial, as the jury in the first trial were unable to reach a verdict. Now, the incident itself occurred following an attempted robbery. CC was 14 years old at the time, almost 15, and CC was also suffering from some addiction issues, which I think is important to bear in mind. Now, the sentencing hearing itself took place over 4 days because there was much discussion between counsel and the trial judge in relation to the sentencing options which were available to the court. As you can all imagine, it's not an easy or straightforward task to sentence a child for such a serious offence. And the defence had expressed a preference for the imposition of a determinate sentence. However, the judge ultimately decided to impose a sentence of life detention with a review after 13 years. So CC subsequently appealed this to the Court of Appeal. Unfortunately, both of the appeals were dismissed. However, it was submitted on CC's behalf that the sentence which had been imposed was disproportionate, wrong, and it was an error in principle. It was also submitted that there was uncertainty in relation to the sentence itself because CC did not know when he was going to be released, and that was actually going to hinder any prospect of CC having a meaningful rehabilitation while in prison. So following this, there was the appeal to the Supreme Court, and the hearing itself took place in October last year. And then this ultimately culminated in the very recent and very welcome decision of the court, which was delivered by Ms. Justice O'Malley on the 13th of March. So that's just a very brief background in relation to the facts of the case.
And so again, like we discussed with Fiona, so those 2 themes that we mentioned in the kind of global context around, I suppose, obviously each jurisdiction, as Fiona has explained, has its own precedents and its own system, but we are seeing a theme in terms of the kind of brain development and neurological evidence and the human rights. So what was the situation in CC? Was brain development mentioned? Was human rights mentioned?
Well, just from my reading of the judgment, the court definitely took into consideration a multitude of factors. So it's quite difficult to narrow it down, but I do think there was a considerable emphasis on brain development evidence, and that was really, really interesting. Actually, in the judgment itself, the court refers to the Scottish Sentencing Council's guidance on sentencing young people. So this was published in 2023, and it basically includes a review of approximately 300 studies on human brain development. Now, what's interesting about this is that this wasn't actually referred to in our submissions, and I don't think it was referred to by the DPP in their submissions either. So the court actually took it upon themselves to include this in the judgment. So I think that's actually quite telling. Also, the court referred to the decision of the Dickey decision and referred to the expert evidence and the expert report that was used. So I actually might just take this opportunity to thank Fiona for her work on that case, but also to you, Nessa, because I know that you were of great assistance in relation to that. And undoubtedly, there was a huge knock-on effect of that decision in relation to CC. So I'd just like to thank you both for that. But then just in relation to case law prior to CC, there has been a very recent tendency and trend, I suppose, by sentencing judges in Ireland to impose a sentence of life detention on children who are convicted of murder in Ireland, with a review element built into the sentencing structure. Now, during the hearing in October, case law to date in relation to the reviewability of sentences was considered in depth. So obviously I'm not going to get into this evening, but I think it's important to refer to a few cases such as DPP and Finn. That was referred to at numerous points during the hearing. And basically, former Chief Justice Keane considered the issue surrounding the legal validity of the review process itself. Also, interestingly, the DPP accepted during the hearing that there's still a level of uncertainty surrounding the lawfulness of the review mechanism. Now, there have been cases in recent years where the courts have seen merit in relation to the review mechanism, such as in the case of DPP and DG, and most recently in the case, the Court of Appeal case of DPP and PB, and that's actually a court case. And the Court of Appeal outlined that there's merit in the review mechanism from a rehabilitative perspective when sentencing juveniles for murder. So that's just a very, very brief summary of the case law prior to CC.
Thanks so much, Cliona. And we'll get an opportunity, I think, in timing-wise, to come back round to everybody for a further reflection. But I might move now to the academic and research perspectives. And I'm going to start with you, Ursula. Obviously, you have a very long history doing research in this area and deep knowledge of particularly of children in detention and their rights. So in terms of the Irish position now after this decision, how do you see whether this has improved our compliance with international standards? And obviously there will be a way to go as well, but can you comment on that position in relation to the convention and the other international standards that Ireland is bound to?
Yeah, thanks, Nessa and everybody. And I'm in an airport, so hopefully won't be interrupted by announcements at any time in the next few minutes. I think that, first of all, it's really welcome to see the judgment coming through. It's the first really substantive, I think, time we've seen the courts engaging with these kinds of issues, in particular the issue of the status of the child in a process like this. And while it's important, I think, that the court recognises the vulnerability of the child, the immaturity of the child, which is really ingrained in the CRC approach, I think it's slightly weaker on some of the other aspects that I'd have expected to see. So we see very clearly youth as a mitigating factor in the judgment and in the court's approach. But I don't think we see the rehabilitative purpose come through quite as strongly as I would have expected. It's there to some extent, but it's not, it's woven through in some elements. But I think, given the strength of what Ian has set out, given Fiona's exposition as well of these issues in other cases, and given how strongly these factors have been in US law, I think we could have expected to see those elements come through beyond, as I said, the child's status as a child, beyond the inherent sort of vulnerability of the child. The fact that, for example, in this case, the court is still saying that the imposition of a life sentence can be imposed where the intentions and actions of the child resemble those of an adult, and we're straight back into the gravity of the offence and so on. So I think there's a different approach being taken here by the court that's not entirely consistent with the CRC, notwithstanding the very positive elements, I think, in particular around the determinate sentence with the part suspended element, which prevents a child coming out of detention, going down the cliff edge into an adult prison system. So I think we still have some way to go to square the circle in all of this, in my view.
Thanks, Ursula. And as I said, I'll come back to everyone on a closing reflection, and I'll probably ask you about kind of, we've probably gone as far as we could in relation to courts. So what would be next steps? But I'll move to Conor now. And Conor, we've been very much in the criminal law and criminal justice space, but we want to take a slightly different perspective on the CC decision in particular. And you're an expert, obviously, in children's rights and constitutional law and the interface between them. So can you give us any reflections that you have around what this decision might add to that wider question of children's rights and constitutional law in Ireland?
Yeah, thanks, Nessa. So we've just about passed the 10-year anniversary of the coming into effect of Article 42A of the Irish Constitution, which is the children's rights provision. It was passed in a referendum that was held in 2012, but it didn't come into effect until 2015. So it's been there for 10 years now, and over those 10 years, I guess a lot of people have been waiting to see what will the courts do with this provision. You know, how will they develop its content, particularly because it's phrased in fairly vague terms. It places an obligation on the state to vindicate children's rights, but it doesn't specify exactly what those rights entail. And we were told, you know, at the time that this amendment was put to a referendum, we were told it would be for the courts to elaborate on its content and the obligations flowing from it. So we've spent the last 10 years waiting with bated breath, I suppose, every time there's been a big Supreme Court case which has touched on these issues, to see how will the court develop this provision and elaborate on it. In this particular case, and this is a little bit of a common trend, I guess, in the cases over the 10 years, the court hasn't done very much with it at all, really. It mentions it in passing. It says that we now have a constitutional protection for the status of childhood, but really doesn't say a lot more about what that means in practical terms. And so we began by mentioning the Dickey case and the importance that the Dickey case had in this judgment. And really, I would think that the comparative jurisprudence was more influential on the court than the constitutional protection for children's rights was. And most of the conclusions that the court reached around the importance of having a different sentencing regime for children compared to adults, and taking into account their stage of development and all of that, I think it probably could have reached all of the conclusions, even if our constitution didn't say anything about children's rights. And to the extent that the Constitution did play a role, I think what was more significant from a constitutional standpoint was the emphasis placed by the court on the principle of the separation of powers. So the court was very clear in stating that the review mechanism in particular was something which couldn't be upheld because of the fact that there wasn't a clear enough legal basis for it. You know, it started out, as you mentioned, with this idea that there was uncertainty about it, but ended up resolving that uncertainty in favour of saying it wouldn't exist unless the legislature provided for it. So that is another example of numerous ones over the years where, in a circumstance where the court had maybe children's rights principles on one hand to consider, but the separation of powers on the other hand, that it resolved the uncertainty in favour of the separation of powers side of that discussion. So even following the insertion of a dedicated provision on children's rights, that sort of broader principle of the separation of powers still seems to carry more weight in our Supreme Court than, for example, the opportunity to do something creative with the children's rights provision. So, the court could have used the children's rights provision to resolve the uncertainty in favor of the review mechanism, potentially. It could even, if it was so minded, if it was really wanting to push the boundaries, use the children's rights provision to push towards a position of saying that you should never have an indeterminate life sentence for children, but never really looked likely to go in that direction at all. And so I suppose that's a difference we see in our Supreme Court in cases concerning children's constitutional rights compared to some constitutional courts or Supreme Courts elsewhere. If you look at South Africa or India or Colombia, where we see some of those courts really pushing the boundaries and using children's constitutional rights to push things at times quite hard. But that same appetite doesn't seem to exist in our Supreme Court, hasn't done to date. And this latest judgment, I think, really is a continuation of that trend.
Thanks so much, Conor. And yeah, it was definitely when I was reading it for the first time thinking, like, would this definitely have been different in South Africa? Or, as you say, some of the other countries that have used the CRC more readily. Thanks so much, Conor, for that slightly different perspective. So we'll have time now to go around to all our panelists again, and I'll have a question to start you off, but certainly there's a little bit of space at least just to add in something that you maybe didn't get to already. So I might start with you, Ian, and I wonder, could you speak to, like, obviously in these cases, as I said at the start, public safety can be a big consideration. Children who do have communication difficulties and that may have different perceptions of risk. I suppose, what does the evidence tell us, or do we have any good international examples around, what rehabilitation and reintegration looks like for these children? Like, does it always have to be in a custodial environment, or do we have any examples of good practice that we could point to rather than just kind of fiddling around with how many years they spend in an adult prison?
Well, that's a small question, which is always easy to answer. So that's great to be put. That sounds like what we call in New Zealand a hospital pass, but that's fine. Look, I think there is good evidence. I think, I think, there is good evidence and there is good examples of therapeutic programs and being delivered with inside prison environments. There's no doubt about that. And I think, but it's probably pockets and pockets within certain countries. And I think that it's often the Department of Corrections get criticised because they're not doing this, they aren't doing that. But actually, what I view them as they're the end of the road, really. They are at the end of the road, and they're the receivers of multiple intergenerational harm, abuse, and neglect. And I think they are, in many places and countries, they're doing their very, very best. And so, I think if you look at sort of coming out of Andrews and Bonter, the risk, needs and responsivity framework that comes out of Canada, if that's adapted culturally in terms of the different country and the cultural framework and the Indigenous population that within which the country is, I think there can be good outcomes. But I'm a person that believes that, prison should be for certain individuals that are at risk to communities. And however, there's a huge amount of evidence that, particularly with young people, but actually, with anybody really, too long in prison actually has its reverse effect. And, I think that has to be kept in mind. I think the minimal amount of incarceration is the ideal, but I think the challenge is the step down from residence to community, prison to community, anywhere. If you look at youth justice, care and protection, prisons, youth units, it's always the integration from the residents to the community that things often are a real challenge, can break down. And I think that, prisons are very, very expensive, and if you look at what the tax dollars are that you spend on this, it's very expensive. And I think if you flip that on its head and think, okay, if that's what it costs to put a young person in prison, then are we using the same amount of money integration, to support them in the community, employment, job skills, etc. And then really, I think you'd say, well, we really aren't doing that. And that's sort of my comment on that. I think you've got to have hope, and I think that you have to have hope that people can change, young people particularly. And I think it requires, people that are committed, passionate, are well-meaning, and are really focused on the best outcomes. And I think where you have a group of professionals, cultural iwi workers, community workers working with that young person, I think you can make a real difference to turning that young person's life around. So, those are just my sort of comments, Nessa. But I'm happy to take any questions here from anybody.
Thanks so much, Ian. And as you say, you have to have hope, and the brain development evidence does tell us as well as the risk in some of these conditions, young people's brains are incredibly plastic and receptive to rehabilitation, and we need to keep that in mind. So Fiona, I might move back to you, and I suppose in terms of, obviously this Dickey decision was released a number of years ago, and what has been the impact in terms of the decisions that have come afterwards? And I was particularly taken, it is a manslaughter case rather than a murder case, of that decision of the High Court a week or so ago, a very considered decision in relation to that young person or that child and their risk to the community. But have we seen a distinct change in sentencing practice, or what has the impact of this decision been in terms of young people who have come before the courts after Dickey?
So one of the key parts of the decision was to recognise that young people may well present with a combination of mitigating factors relating to them and to the offence that are likely to be able to establish manifest injustice. And as a result of that, we have definitely seen in the sentencing of young people since Dickey far more use of determinate sentences with lesser minimum periods of imprisonment. We've also had what you might expect, some historical cases. There were a group of 5 of them who went up to the Court of Appeal and said, well, we should have had a lesser sentence. Of those 5, only 1 had leave granted, but his appeal was allowed. Perhaps more significantly, we've actually seen an impact on wider murder sentencings, and this recognition that people can present with a combination of mitigating factors such that it could be manifestly unjust. So that's been quite interesting. However, we've also had a recent case as well, which talked about risk and dangerousness and that balancing exercise, where it's been established, well, you might need life imprisonment because of that. So it's definitely had an impact, Nessa.
And that is an interesting point, Fiona, about that double-edged sword sometimes of this evidence about people's brain development or their risks, that it can be both a mitigating factor, but some judges, certainly I've seen that as well, would treat that as an element of dangerousness, and certainly we've seen that in the US as well. So Clean, I might pose really essentially that same question to you. I mean, obviously the CC decision is much more recent, but obviously we had a case even today, which I haven't seen the actual judgment, but it seems to have produced a determinate sentence. So what do you think the impact of this CC decision might be in terms of the young people who are sentenced after this decision?
Well, the main takeaway for me from the CC decision is that now we know that the most appropriate way to sentence a child in Ireland in relation to a murder offence is to impose a determinate sentence with a partly suspended element, as Ursula mentioned a while ago. Having a determinate sentence, it's the best option. It's of a fixed length. There's certainty. There's a target date for a child, for a juvenile. And I think that's very significant. Just in terms of the decision itself, one of the best outcomes is that CC and those who find themselves in a similar situation to CC can now have their sentence reconsidered and perhaps resentenced, which is a very positive development. Also now it's possible to suspend a portion of a sentence, which is a sentence of detention, which is imposed on a child. And we didn't think that this was going to be possible prior to the decision in CC. Then I suppose in relation to anonymity, CC has also retained his anonymity. Now, I know that's more to do with PB, the decision in PB, but that was also heard at the same time as CC. And that's also a fantastic outcome, which we weren't expecting. So despite the fact that CC had aged out and reached the age of majority before the Supreme Court appeal, he will now retain his anonymity, which is really great.
Fantastic. And I think we could actually host another session about the name suppression and identity, because it's another fascinating aspect. Thank you, Cliona. So I might move to you now, Ursula. And you know, we've discussed that there are probably limits to what you can do in relation to sentencing precedent. But what would be the next steps in your view if we were to really try and align this area of the youth justice system with the international principles and those best evidence?
Well, I think one of the really important things about this case is that it reinforces, certainly in the public eye and in law, that serious crime cases involving children who commit murder are youth justice cases. I think the law, as it was defined under the Children Act, largely focused on offences charged in the Children Court, which are relatively minor in nature, and we have a whole host of provisions that only apply in that context. I think one of them actually doesn't. One of them that has wide application is Section 96, which is effectively our sentencing principles. Surprisingly, they got relatively little analysis in the judgment. They really do provide a good framework. But I've always questioned the extent to which they would actually be applied in these kinds of cases, because they require courts to take account of the family relationships, of the child's reintegration, education, and so on. So I think that's one of the important things for me. The other one is the court process. Cliona mentioned a really critical issue of anonymity, and that's not clear under the Children Act, and so it would be really good to have that copper fastened. And actually court process issues. They're currently, in my view, certainly in the higher courts, by judicial design rather than by law. And I think that's another area where we really need to reinforce that the reality of this process for children is extremely difficult and challenging and not child appropriate. So I think there's a whole range of things there that will hopefully allow us now to focus on all children charged with offences, not just those charged in and tried in the junior courts.
Thanks so much, Ursula. Conor, I might move to you now. And I suppose we were discussing in a corridor conversation the other day about some of the balancing of rights cases that are issues that obviously in a lot of these cases, both the child or the perpetrator is a child, but also the victim is a child as well. So in terms of, I suppose, the children's rights framework, you know, how does the children's rights framework help us to deal with those very difficult issues of I suppose, competing and overlapping rights?
Yeah, that's a really interesting one, because when you study the sort of constitutional cases around sentencing and children's rights, most of the cases that you come across, or at least that I've come across in my own research, in which children's rights are invoked in that context, it's often around cases where an adult has committed an offence against a child. So typically child sex abuse cases. And there's lots of judgments from around the world where different courts have invoked children's constitutional rights so as to justify the severity of the sentence handed down to the perpetrator. So typically what you're looking at is an appeal against a sentence, arguing that it's been too harsh, and then a court on appeal upholding the sentence on the basis that it's necessary to take this harsh approach in order to vindicate the right of the child victim to be protected from sexual abuse. That, of course, becomes very complicated and murky then if both the victim and the perpetrator are under the age of majority at the time. Came across a very interesting case recently from Eswatini in which this arose, in which the court in Eswatini did exactly that. It basically said that this particular perpetrator needed to receive a mandatory minimum sentence in order to uphold children's rights. Whereas, of course, as we're all familiar with here, the output of the Committee on the Rights of the Child and so on would very much stress that mandatory minimum sentences should never be applied to people who commit offences while they are underage. So it's an interesting example of how children's rights principles can pull in two different directions at once. And, you know, I guess ultimately the view of that decision from Eswatini, ultimately from most children's rights commentators, will be that it's not children's rights compliant, that in that particular instance, the rights of the perpetrator actually would be the ones that require more weight attached to them. But certainly, if you read that particular judgment, that judge would not be impressed by that argument and would take an awful lot of issue with it. There's a line in it in which he essentially says, "Well, what about the rights of the child victim who has been raped?" You know, so it's a tension. Whenever you have rights clashing, in any case, it's always a difficult thing to resolve. I suppose when you have children's rights conflicting with the rights of an adult, we point to the best interest principle, and we argue for the primacy of the child's rights in that context. But certainly, it's more difficult to reach a very clear conclusion, an easy answer in cases where it is the rights of two different children that are pulling in opposite directions.
Brilliant, thanks, Conor. And you know, it's just a reminder, I think, that so often in these cases we do focus very much on the perpetrating child, but there are often other children's interests around as well. So I'm reminded of the Supreme Court case in New Zealand last year about name suppression of young people, where there was some discussion as well about the interests of young people currently and future young people as well. So we'll move to begin to close off now, but we do probably have time for one audience question. Actually, Ian, you said you'd answer questions, and actually somebody has come through with a question around one of our colleagues from South Africa talking about rehabilitation. And I'm wondering whether you can speak to whether there is any kind of data or evidence around, I suppose, the children who have different sentences. So, you know, children who serve life imprisonment and might get out after a long period in prison, you know, their reoffending rates versus children that have a more evidence-based response. So do we have evidence, particularly around rehabilitation and public safety?
Well, me being an optimist, I'd say it's there. I think it's interesting. I don't know whether you're going to put the emails out, our email addresses, Nessa, but the person could email me. Me and my colleagues wrote a paper about the negative impact of incarceration on juveniles, and it was published in a journal, psychology journal called Clinical Psychology Review. It's probably about 10 years old now, but that gets cited, and it may be interesting to look at the site, who's citing that. I mean, I think, it's interesting. I mean, I've visited a lot of prisons and youth justice facilities around the world, and a lot in the United States. And I know the United States gets a lot of bad press for its incarceration of Black and African American and Indigenous population. On the other side of it, I've seen some very good rehabilitation programs there, and you know, and so I think that there is. I think it's probably patchy. And I think, but you know, if you were to email me, then I can see what I can find for you to assist there. How's that for a sort of a vague answer?
That's so kind, Ian. Thank you. And I'm sure our South African colleague can look you up, or I can help with that link. So I might just close this off now with a couple of remarks. So thanks so much for joining us. And I feel like we could probably go on for a couple of hours, and I'm already thinking maybe in 6 months we have one about name suppression and identity. But it's obviously a topic, like I was really taken, which is why I was so interested in hosting this, you know, just about the spread of those ideas internationally. And, you know, to hear Tina saying how important the Dickey case was. And as I said, I've been in contact with Canadian colleagues who are taking a similar case. So it's just the importance, I think, of that, the awareness of these cases internationally, because clearly the judges are aware of them and find them quite influential. So I think that's very important. And again, we've seen those US cases that are now 10 or 15 years old being repeatedly cited around the world as well, just showing the importance of that global approach. But I think probably another theme that we've seen is that there is obviously a limit to legitimately to what courts can do within national frameworks, and the importance of obviously of precedent. And that idea that probably to have to move the conversation past just, I suppose, those ideas around how much time a young person should spend in the adult prison, and we will require legislative reform, because many of these issues have arisen in New Zealand and Ireland, certainly because there wasn't probably explicit thought given to the situation of children and young people. New Zealand Sentencing Act doesn't have a specific case for it. And the Irish legislation, it appeared to be, I think, probably some kind of oversight that these pathway for these cases wasn't specifically provided for. So probably the answer does have to be law reform in terms of that specific jurisdictional, moving the jurisdiction to a children's court or having those sentences available. But it probably again doesn't still tackle that question which Ian was getting to, around what actually is a principled response that would address the young person's needs and keep the public safe, which is of course the purpose of sentencing. So again, thank you so much for the rich conversation, and thank you particularly to our colleagues from Aotearoa New Zealand for getting up so early. I do it myself quite a bit, so I know it makes the day long, so thank you so much. And thank you, Cliona, for joining us, and to my colleagues at UCC. So we're going to wait until we get hold of Marsha's recording, and I'll put those together in one recording so that we have the US perspective as well. And we'll certainly email that out to everybody. And we'll also include links so I can talk to you, Ian, about that, about anything that we talked about, and particularly some of the work that UCC academics have done in this space. So again, thank you so much. There's been, the audience has been stayed with us, and new people have been coming in as well. So thank you for joining us, and thanks again to our speakers for making the time. So I really enjoyed listening to it myself. All right, take care, everybody. Bye. Bye-bye.